Mr. LaRoe, I see that you're on, but you need to turn on your camera and unmute your mic. There we go. All right, good morning. How are you all this morning?
Very good, thank you.
Ms. Day, you going to reserve 5 minutes?
Yes, Your Honor.
Okay, go ahead, please.
May it please the court. My name is Nikki Day, practicing with the law firm Bryant Miller Olive. I'm board certified in city, county, and local government law, and I represent the city of Northport in this case. We're before you today on second-tier certiorari appeal, asking
Ms. Day, can I jump in right here? I just, from my perspective, I'd just like to tee this up, and then you can guide me from there.
Absolutely.
Like you say, we're here on a second-tier cert, which means our review is very narrow, and we have to determine whether the circuit court afforded due process and whether it departed from the essential requirements of the law. So it seems to me we're here on the second prong, not the first prong, the essential requirements of the law. The circuit court held that the city may only reject a petition for contraction based on lack of feasibility. The court concluded that means it's technically possible without consideration of public impacts or value judgments, and excludes consideration as to whether the contraction is possible, not whether it should be done. So the bottom line is the court determined what feasibility in a way that you didn't care for. And sort of to finish my thought, and then I'll let you take it from here. The Supreme Court in Haines City versus Higgs, in determining this question, what is a departure from the essential requirements of the law, held that a decision may be made according to the form of the law and the rules prescribed for rendering it, although it may be erroneous in its conclusion as applied to the facts. It is not an illegal or irregular act remedial on certiorari. So the Supreme Court's basically suggesting that your issue with the word feasibility, even if you're right, and the circuit court is wrong, that's not a departure from the essential requirements of the law. So why don't you take it from there?
Sure, Your Honor, and I would agree with largely the beginning intro, but with a few distinct points that I think are important for this court. First, the case has been characterized as one over rejecting a petition for contraction. The statute's very clear on what the petition is asking the Northport City Commission to do as a governing body. The petition clearly directs the city to do immediately two things. One, shall undertake the study of feasibility, and two, shall within 6 months, and here's the fork in the road, either choose to introduce an ordinance initiating the proceedings under subsection 1 to continue with contraction, or 2, reject and specifically state the factual reasons for rejection. That is the direction and the preemptive charge to the city commission in this case. And I agree with Your Honor, we are under a limited scope of review here on second-tier certiorari appeal. And we wouldn't be here if the court's failure to apply the correct law of statutory construction was carried out in the matter below. And that's why we're here.
If I may,
I'm
Ms.
sorry,
Day,
Go ahead.
Go ahead.
but if I may, Ms. Day, I guess this is where I want you to clarify. You said that the trial court was wrong and misapplying the statute. But if you look at the statute, the term feasibility, it's nowhere near it's not really defined anywhere in the statute. So what does feasibility mean? Your whole crux is saying, you're basically taking the position the trial court was wrong in coming to the conclusion what the term feasibility means. But with all due respect, your position, you're injecting added factors under feasibility that's nowhere near set forth in the statute. So if you look at the statute, and let's look at it together, okay? Statute that we're dealing with, section 171.051 paren 2. And it mentioned feasibility. It's not defined at all in there. And the circuit court basically looked at the plain language and interpreted it as feasibility as being capable of being done. So where in the statute does it have in there that the city and, you know, all these other factors that the city is saying that it considered, aren't you reading that into the definition of feasibility?
Actually, Your Honor, I think it's the opposite. The fact that feasibility is not defined in the statute does not mean that it is required to be given its most narrow application. In fact, that's against the statutory laws of construction. I want to try to answer both of your questions at the same time. First, Judge Morris, you're absolutely right, and we are not asking the court to make an interpretation, misapplying the interpretation is not the issue here. The issue here, and with all due respect, a lot of emphasis has been placed on one word in the statute, feasibility. I think too much emphasis, particularly when you look at this is directing the procedures for the city commission as the governing body to move forward. There are all different kinds of statutes, Your Honor, and I most recently cited the Emerson Supreme Court case interpreting a preemptive statute which gave discretion to the governing body. In that case, it was the Board of County Commissioners over a tax issue, but it gave discretion. The statute gave a long laundry list of things that the Board of Commissions could choose. And in fact, in that case, the voters attempted to limit that discretion by a charter referendum. They said, of these different cafeteria items that you can choose from, Board of County Commissioners, we only want you to choose these. And the Supreme Court came back and squarely said, we need to read the words in the statute that are there. And just because discretion has been given to a governing body to choose whether to move forward with something, that does not insinuate a legislative endorsement of unbridled discretion. It does not mean that we are reading into concepts of feasibility that aren't there in the plain definitions too. The plain definitions cited by the circuit court say capable of being done successfully. Well, what does that mean in a preemptive statute directed at legislative officials with fiduciary responsibilities, all of the regular parameters that exist on their decision-making? There is no substantive issue here taken with the court for any of the 5 reasons stated for rejection.
But if I may, if I may, you keep saying that, but where in that statute does it say that the city has clear authority, that it should have the discretion to consider additional factor? Where in section 171 does it say that?
We have to know that the word feasibility, in fact, what happened was the circuit court read limitations into that word that weren't there. The word feasibility is entitled to be given its plain and ordinary meaning, which does mean capable of being done successfully. So there is some relative check on the resources, on the other things that the city commission needs to consider when determining whether to introduce an ordinance of this magnitude. And I want to go back for one specific second, because this is the first time that the second district court or any district court has been asked to interpret the rejection of a voter's petition requesting a governing body to introduce an ordinance of this kind. However, this is not there has been persuasive authority existing for many years on these points, and the city commission followed that persuasive authority at that time. And so, in fact, Your Honor, what we have to do is look at the word feasibility, and we have to know that it means something more than just the technical possibility of meeting the ultimate contraction criteria that's found in 171.052. And here's how. Because when the legislature wanted to direct the city commission to look at the annexation criteria of 160.163 and must include it, it is only if it elects to proceed with introducing an ordinance. That exact language is found in subsection 3. So we see from the plain reading that when the legislature wanted to direct the city to only analyze that annexation criteria of section 171.043, we see that in a direct cross-reference in number 3. So we know it has to mean feasibility has to mean something more than that to give meaning to all the words used in the statute. Simply, the issue is the opposite, Your Honor. The statute doesn't say the limitations that the court read into it. And to Judge Morris's point, the Florida Supreme Court more recently in 2012 from Heggs in the Nader versus the Florida Department of Highway Safety Motor Vehicles squarely determined that a departure from the essential requirements of law can appear on the face of a statute. And here what we have is a failure to apply those correct laws of statutory construction to say we have to give meaning to the fact that the legislature used the cross-reference to the annexation criteria in subsection 3. We have to give meaning to the fact that when we're looking at the charge in response to a petition, what the city is required to do, there are two things, there are two shalls in there. One, immediately undertake a study of the feasibility of the proposal. That's actually the municipality as a whole to which it's directed. Interestingly, the Florida Supreme Court does analyze in that same Emerson case when instructions are given to the entity and when instructions are given to the governing body. And when they're given to the entity, that's undisputed in this case, Your Honor, that the city staff immediately engaged its administrative resources to undertake a feasibility of the study of the petition. The petition in this case is asking the Northport Commission to introduce an ordinance to contract its boundaries of over 8,000 acres in the Welland Park development. It conducted a very extensive study, and then there's a fork in the road at 6 months. We know there's a fork in the road because the statute then directs a second and shall do one of two things: either introduce proceedings under subsection 1, meaning proceedings haven't even begun at this point. They only began, and the statute specifically directs that they can only be initiated by the governing body. The Florida Supreme Court in the Emerson case is clear. We have to give effect to the fact that the statute's directing the governing body to do something different than when it's immediately instructing its staff to study the feasibility. So then there's a decision point for the governing body. Either introduce an ordinance, which is going to continue further proceedings, which are going to then require 2 additional noticed public hearings. And it's only after this point that the circuit court says all those things you considered before, those were all proper. They were all within the proper bounds of rational basis for our government decision making. These are not government decisions are not standardless, and none of that is at issue in this case. The court concedes that all 5 matters were proper governmental interest matters for the governing body to consider. It just says, well, you can't consider those until you have 2 more public hearings. This was an all-day 8-hour public hearing where the city commission already heard from over 12 witnesses and through hours of testimony. But the court says you need to have 2 more public hearings, but then you can appropriately consider and reject a contraction ordinance that you really had the decision back at point 2 of whether to introduce in the first place. So we have to give meaning to that process. These are preempted processes that have to be followed. And at this point, the petition had been rejected. 5 reasons were specifically stated for the rejection. And at that point, there are no proceedings continuing forward. So that's the issue in this case. And after an all-day public hearing, the Northport City Commission did vote to unanimously to reject the petition rather than move forward with introducing an ordinance for contraction. And this case is important to how municipalities plan and rely on their boundaries. That's why the Florida Supreme Court is here as an amici or as a friend of the court. Our stable boundaries, but more important, our stable processes matter. And I will never forget, if I can just share with the panel, the first time.
But before you do that, Ms. Day,
yes,
because you're running out of time, I want you to address one of the issues that Mr. Lohr brought up. How do you respond to the fact that in the first place, the annexation was not really valid from the get-go? How do you respond to that?
Your Honor, I think this was an annexation that was finalized over 20 years ago. Since then, the area has been comprehensively planned, developed, utilities and infrastructure have been installed.
No, I understand that, but
so, Your Honor, we don't look at, but Your Honor, there's nothing in the statute that instructs the city is supposed to not look at the realities of urbanization. In fact, the legislative charge, the purpose of the statute states that it is to effectuate sound growth and to accommodate the growth, excuse me, I was just trying to find the exact legislative, but if you look at the legislative purpose of the act, the city commission's actually instructed to look at whether or not this facilitates those purpose. So actually, I think it presents an improper collateral attack on an annexation that was finalized over 20 years ago. Decisions have been made since that time. And if I am running out of time, I have to point to one thing to the court, because this is so squarely outside. We have two issues here. We have the statutory interpretation issue, which I think we've addressed, but we also have the issue of the limited scope of the circuit court's review that it had on first tier certiorari appeal. And there are glaring instances where that has been exceeded. Most glaring is in the treatment of the sheriff's affidavit. I have to use that in quotes because that's the language that the court's order uses, but to even accept it as what it purports to be injects documents into the record, which should be sacred, not only on appeal, but particularly on first tier certiorari appeal. There's countless cases cited to the court where going outside of the competent substantial evidence that supports the city commission's decision far exceeds the limited scope that the circuit court had on first tier certiorari review. And importantly, and the most glaring example of that is in that document that is undisputed, was not in the record, was injected for the first time in these proceedings by the West Villagers in an attachment to their reply brief. The court then considered the contents, called it what it purports to be, commented upon its veracity, and 3 times recommended that the city commission reopen its evidence to consider its contents. There is case after case cited where circuit courts commented on far less, and it was determined by the reviewing court on second tier certiorari to be plainly a departure from the essential requirements of law for exceeding the proper scope of review. So that's what we're here to talk with you about today. You don't have to decide. This case is not one about policy. This case is not one about whether you agree. This court agrees with the Northport City Commission, but the Northport City Commission was the finder of fact in this matter. They were the lower tribunal. The lower court was on a narrow scope of review. It was far outseated, and Your Honor, we're here today asking that the court quash the opinion in its entirety and enter instructions for the court to enter an order that bases its consideration only on the record of the proceedings before the commission, that it confine its review to simply whether the commission's decision was supported by competent substantial evidence, with no discussion, as goes on in this 20-page order, with lengthy discussion casting doubt on certain witnesses and bolstering others. And finally, that the court instruct that the statute be construed with its plain meaning, and feasibility must mean something more than that annexation criteria. Thank you.
Thank you. You'll have 5 minutes when you return. Mr. LaRoe?
Good morning. May it please the court. Luke LaRoe here. I represent West Villagers for Responsible Government and John Meisel. And we're here today to focus on the issues of the circuit court's order that I think have been somewhat lost in the shuffle. I know that there's been a great deal of attention paid to the construction of the term feasibility, but one of the issues that I want to stress is that the circuit court, in reaching its conclusion, focused not just on the concern of how that term was interpreted, and should I say misinterpreted by the presentation of evidence during the hearing, but the fact that when the city issued its decision as required by the statute, they didn't specifically state the facts upon which the rejection is based. And I would urge this court to resist the argument that this statute is somewhat able to be disconnected, that you have the feasibility study they asked for, there's a deadline to do so. But I think the fundamental beginning point is that this is an area that reflects the democracy of what the voters would like. I think that there's no question that my clients complied with the initial accumulation of all of the proper petitions from the qualified voters. Those were confirmed by the election officer in Sarasota County. So I think that throughout the earlier decisions of the circuit court, it's been recognized that since at least 1869, there's been an opportunity for citizens that are part of a municipality to seek a de-annexation or contraction of that property. And I think that what I see consistently throughout all this is that that issue needs to be ignored, that if there's any concerned with the difficulty of accomplishing a de-annexation or contraction, that automatically it should be rejected. And I think that that certainly is irreconcilable with the legislative goal of allowing voters to have some say in the jurisdiction and where they live. Now, again, focusing specifically on this, and I know that the difference between the three parts, the three criteria for an initial petition for writ of certiorari, what's missing is obviously, was there competent substantial evidence? So obviously this court is bound by the circuit court's findings. And while there was a specific discussion of what evidence was presented during the hearing, what the circuit court said was that, because the interpretation of the term feasibility was really far too narrow and far too burdensome on the whole process, and not what the statute defines feasibility as, that it invited error. It invited the city to depart from the central requirements of the law. But what I really want to stress is that not only was that a very big issue to the circuit court, but the findings that were made are relatively generic. I mean, there are really no facts that are anywhere in any of those findings. And I think if you look at it, and I'll just comment on what the findings were and then what the circuit court observed, it said, one, the area meets the criteria for Florida statute section 171.043. Therefore, this area is not appropriate for contraction. Well, obviously, as you've observed, we feel that this annexation should never have taken place. And the fact that it might be 20 years ago or 150 years ago doesn't change the geographical characteristics of this area. It's separated by the Myakka River. Nothing has changed that, and there really have been no changes since then. And I think that we cite in our briefing the fact that there was an ordinance finding that under the very same geographical characteristics, it was not appropriate for annexation. And there was another opinion letter from the city attorney dated 1989. Again, no change in the geographical characteristics, that annexation just simply wasn't appropriate. So what the circuit court said in dealing with the city's finding was that there are many, many subparts to 171.043. I cannot conclude that your findings were based on competent substantial evidence because you don't tell me which of those subparts you focused on. It's just simply a finding that it's not appropriate, but there are no facts to support that. It's just simply a conclusion. And I think that the circuit court criticized all of those findings as more conclusions than any kind of factual analysis. The other statement, I think, could be made by any municipality in any context. It says that public health and safety are our primary responsibilities for all citizens of Northport. Well, it's not really a finding of fact. That's really just a statement. And I think that just goes to the very fundamentals. But in order for these findings to have met with the specific requirements of the statute, there need to have been statements showing with some specificity what supported that. And I think what the city did is they referenced, we had a hearing for a whole day, and these are our findings.
And Mr. Lareau,
Yes.
Lareau, can I like to look at this case for what it is. This is, Ms. Day has a real tough burden. We're up here for a second-tier cert, not just simply an appeal, a direct appeal, second-tier cert. And I think that goes back to what Judge Morris earlier was questioning Ms. Day, that this is an extraordinary high burden for her to come forward and telling us that why the court was wrong. Because again, the higher it goes up on review for second-tier cert, the more narrow. So for us, we don't get into the facts of what is substantial competent evidence. We don't get into that. We just have to look to see, was there due process? Was it done? Was there any violation, of due process? Was there a departure from the essential requirements of law? And again, so when we talk about feasibility and certain factors that were considered or not considered, even if she was correct on all of that, because we are reviewing it on a second-tier cert, we're limited in our review in this case. So having said all that, a lot was mentioned about the affidavit of the sheriff. My reading of the opinion, and help me if I'm wrong, it looks like the court addressed it, but then said, I cannot rely on it because it was after the fact. So was there anything in the judge's opinion that indicated that she relied on that affidavit to support her conclusions?
Absolutely not. In fact, it was pure dicta. It was not part of what the court considered. The court considered the interpretation of the term feasibility and the absence of specificity in the findings. Those were the core issues, both within the statutes, both required of the city, that the city never did. And that was the basis that the circuit court found that the city departed from the essential requirements of the law. The only mention of that, and I would note that the city never filed a motion to strike that affidavit, but the affidavit was referred to subject to the remand. If we remand, which the court did, maybe the city might want to consider this because no one else did. And if the Munalytics folks were going to do their job properly, and this is just a comment, and again, just dicta and nothing to do with the ultimate decision of the circuit court, if you're going to criticize the ability of what we call the embracing county to provide fire and police and other public safety issues, you might have wanted to talk to him. And in fact, the sheriff was the one that reached out to us. So we felt that not to change the basis of the record. And I think even in our presentation of that, we said, we're not trying to change the record. The record speaks for itself. It's what it is. But we just thought that that was something that we'd throw in. And when the court commented on that, that was only relative to consideration after the remand, which was a decision made on those other two issues.
And to make it clear, Mr. Lowe, the trial court did not rely on this what let's designate as an improper affidavit to come to the conclusion in which it did, correct?
That is absolutely correct.
All right.
Absolutely correct. The other issue that I really want to focus on is that there's some argument made that the circuit court was somewhat overwhelmingly restricted in coming up with the definition of feasibility that it did. And what I think the circuit court did do was it was surgical in the way that it went through its analysis. It cited proper case law from the Florida Supreme Court, and it followed all of the dictates that are allowed for a circuit court to interpret a statute. Yes, feasibility is not defined. So what did the circuit court do? It looked at the fact that, well, this statute was adopted in 1974. Let's take a look at what the definition of feasibility was in Black's Law Dictionary from 1974. And it's obviously more consistent with what I think the common understanding of feasibility. Could it be done? Is it possible? Not that it's preferable or any of the efforts that the city makes to try to make feasibility essentially a positive or a finding that it has to have 100% approval, or it needs to be entirely fiscally perfect, or any of those things. None of that is part of the statute. None of that was part of the circuit court's analysis. But what the circuit court then did is it looked at other dictionary definitions, going, I think, the Black's Law Dictionary from 1990, Webster's Dictionary, and found that the general common sense definition of feasible is what we've argued it could be and what we think the statutes embrace. Can it be done? Is it possible? And I think the other big—
Mr. LaRoe, given that we are on second tier cert, in your view, how deeply can this court wade into the issue of the lower court's interpretation of feasibility?
I think it can only wade into that if it's just evident that it's a departure from the essential requirements of law. And I would respectfully submit that the explanation as to how the circuit court made that interpretation is entirely consistent with the requirements of law. So I don't think you wade into that whatsoever.
But the circuit court basically did a textualist interpretation, which is pretty much trying to determine the plain meaning of the statute. And there seems to be disagreement about how that textualist plain meaning analysis should be done. So no one's complaining that the wrong statute was applied, or that there was, a completely misreading of the statute. It's simply this very fine point of how do you determine feasibility? How do you define that word? And we're down to a textualist analysis of that. And it seems like the textualists don't agree here. That doesn't seem to be even close to a departure from the essential requirements of the law based on the Higgs versus Haines City Supreme Court decision that says, we're not going to get into the weeds on that type of thing. I mean, it's hard to read it any other way, I think.
I would have to agree. I think the interpretation stands I don't know that there's that much of a textual disagreement. I think the observations of the circuit court were that the city's efforts to construe this, or more candidly, Munalytics' efforts to construe it in their feasibility study, added an incredibly more burdensome analysis of what is feasible and what is not feasible. And I have to comment on one issue here, and I don't know that it actually entered into the findings of fact below, but throughout this, and I think also with the League of Cities amicus brief, there's this fear that this is going to somehow open the floodgates to people challenging the municipalities or trying to contract whatever property meets with the other statutory requirements.
Is that relevant to our analysis on second tier cert?
It really isn't, because I simply wanted to comment on the amicus brief. I would feel that I would be remiss if not, but the bottom line is that I think the arguments made by the city and the arguments made by the League of Cities urge this court to use a different definition and a different analysis than what the statute's plain language clearly supports. And that's really what I think the fundamental issue here is. I think that the circuit court made its findings. I think those findings are sacrosanct. I don't think that there's any evidence whatsoever that any of those findings departed from the essential requirements of law. And fundamentally, I think that's the end of the discussion. I think that the speculation and, quite honestly, again, the absence of any recognition that the statutes themselves accommodate for these transitions. There's language that say, hey, we'll accommodate for this, the city and the county can get together. You know, I don't think that that was really part of what the circuit court observed, but it's mentioned once that nobody brought that up. We brought it up, but everybody else, you know, basically saying that the sky is falling, didn't pay any attention to the other contents of the statute that allow for what I would respectfully submit should be a comfortable and cooperative transition. It's not the end of the world, and the statutes don't dictate that it's the end of the world should a contraction properly take place. So from our perspective, there's absolutely no question that there was due process allowed in all of these proceedings. And I don't think that there's any evidence whatsoever that the circuit court departed from the essential requirements of law. So based on those two respectful submittals, I would respectfully submit the circuit court should be affirmed.
Thank you.
Thank you.
Ms. Day, you have 5 minutes.
Thank you. And I do have some matters to respond to. Some comments were made about information dating back to 1869. I think this is important for the court to consider the context that this statute was adopted in. This was immediately after and part of the implementing statutory implementation of the 1968 constitutional revision, which completely took local government law and turned it on its head. It went from a system of delegated authority to home rule authority, and that's not what this case is about. But going back to authorities to 1869 or anything prior to the 1968 Constitution simply doesn't apply in our current system of preemption. In 1974, this is when the statutes are implemented, along with the Sunshine Law and all the other statutes that were directed by the legislature to be implemented as a result of the 1968 Constitution. In 1976, the Attorney General issues an opinion that's directly in line with what the City Commission did in this case. It's an opinion specifically on the procedures to be followed under the Contraction Act. And Judge Morris, you asked a question about, well, isn't this just over the interpretation of one word in a statute? And under Higgs, we don't get into that. No, this is about a distortion of the entire interpretation of the procedures that are dictated in 171.051 subsection 2. Procedures that, after being advised by the Attorney General in 1976, and the Village of Wellington case, by the way, cited a 2018 case in the Southern Third Reporter, states that these Attorney General opinions, which have long guided the local government decisions, are entitled to great deference. Instead, it's summarily disposed of, receded from, and the court instead proceeds to inject for the first time a narrow definition of feasibility that has never been applied to this statute since its enaction in 1976. When that Attorney General opinion came out, the legislature did not do anything to change the statute. when the Vonsic case was decided and when the Orlampa case was decided, no legislative changes were made to the statute. And so this was not without persuasive authority guiding the commission's decision here. And I think that's important for the court because those are just summarily receded from without any analysis. And I want to go back to, because there's two more important points I want the court to consider. This idea that there are not enough facts stated is a ruse. The court did not even consider 2 of the 5 facts stated by the commission. And even in rebuttal, you didn't hear anything about finding number 3. Contraction is not feasible due to existing urbanization. Urbanization is an ultimate fact. There is nothing in the statute that says the statute must specify evidentiary facts versus adjudicative facts versus ultimate facts. It says must state facts. So the limited role of the circuit court was to review the city commission's decision, its unanimous vote. And by the way, the city commission must act together as a whole. As you all know, they have to follow the sunshine. They can't go into a back room and talk about their order and write out a bunch of things with evidentiary facts. They have to sit together on the dais, which is what they did. And after a nearly 8-hour public hearing, they deliberated, moved, amended their motion, and arrived at 5 specific reasons for rejecting the petition. And the circuit court's order spends all of its time disputing number 1, does not mention and refuses to acknowledge numbers 2 through 5, and number 3 and 5 are telling here. These are ultimate facts. Contraction is not fiscally neutral. Number 5, that's an ultimate fact. And for the city commission to do that as a whole, unanimously must arrive at the decision in the sunshine, I think pretty clearly communicated the specific facts that based its rejection and certainly in compliance with the statute when again, there is nothing, we have to read the statute for what's there. There are no words there saying evidentiary facts. In fact, the statute doesn't even use the word findings. It uses the word findings in subsection 3 below. It does not even use the word findings in subsection 2. So this has all been distorted to somehow say, we're going to put a blinder on and not even look at 2 of the 5 reasons stated by the commission, which are factual, and instead use that as a way to skirt the limited role that the circuit court had as well on first tier review. You're right, Your Honor, this is a limited second tier review, but we wouldn't be here if this court's order doesn't go so far beyond the bounds of first tier review that it's necessary. The respondent even just noted that the circuit court's factual findings, we shouldn't have any factual findings in a first tier certiorari review. And yes, the circuit court acknowledged that the affidavit was outside of the record, but then it proceeded to comment on it, discuss it, accept it for what it purports to be, call it troubling, and then repeatedly suggested the city commission reopen its evidence to address its contents. With all due respect, whether or not the court specifically based its order on that, based on all of the case law that has been cited to you, that is entirely outside of the scope of first tier review and is reversible. And the seriousness of this error is, it undermines our entire appellate process. The Florida Power and Light case versus—
You're way over time now. You're way over time.
Thank you.
Okay. Okay. Thank you both. Your briefs were excellent. Your arguments were passionate and very helpful, and we appreciate it.
Thank you for the
Yes.
privilege.
Thank
Have a good day, all. Thank you very much.
Thank you all. Thank you.